Good morning, everyone, and welcome to this latest webinar from Fieldfisher Silicon Valley. Today's webinar is focused on the COVID-19 vaccine and whether you can mandate the vaccine across your international workforce and all of the issues associated with that. Judging by the number of questions we are fielding on this exact topic, we know that a lot of legal and HR teams are grappling with these issues as they consider their businesses return to work plans across the globe. For those of you that don't know me, I'm William Devenish. I'm a director in the corporate team in our Silicon Valley office. I'm going to be moderating today's session, and I'm joined by my two amazing Silicon Valley-based colleagues, Gemma Chubb and Megan Ward. Gemma's a director in the employment team, and Megan is a privacy advisor. It's not going to come as any surprise to any of you that there's a lot to unpack around this topic. We've decided to keep things snappy. The chat function is open, so please do ask questions as we go. If we don't get round to answering your question, we'll reach out to you afterwards. Right, let's dig in. Gemma, as businesses are considering what the future of work looks like in this kind of post-COVID-19 world, it'd be great to get your views on probably the most contentious question, which is, can a business mandate the COVID-19 vaccination across their international workforce?
Yeah, you're right. That is the biggest question. Guys, nod if you can hear me, will you? You can? Good. Yeah, look, we've been getting this question constantly for the last few weeks. Either in the context of our clients getting their workforce back to the office, or if they're already back to the office, which many are in Europe. That's one thing to bear in mind, that many people are already and have been back in the office for a long time. Then they're thinking about how to ensure the continued safety of their workforce, particularly in light of the fact that we're going into the winter and there's probably going to be another surge. President Biden issued a call in the last few weeks for vaccination to become mandatory in the private sector. And so many of our US headquartered clients and our clients out here are wondering if they can do the same thing as they're doing here overseas. And we've been tracking the progress of these matters across the world. But simply because of time today, and we are going to try to keep this to a quick and snappy 25 minutes or so, give or take a little bit, but we're going to focus on the EU and the UK because typically they are the most difficult jurisdictions to do this sort of thing, to get this sort of information and to get these sort of programs off the ground. I know I spoke to a few clients about this, and when I first started brainstorming this session with Will and Meg, and what we had in mind is that we would kind of do a headline type session where we said, you know, this is what you can do in this country, this is what you can do in that country. We kind of quickly realized that was going to be a bit boring just hearing us reel off facts. So what we're going to do instead is to answer these questions and highlight for you some key issues, but then hopefully identify ways for you to mitigate your risk, things to bear in mind when you plan on rolling these things out. Lastly, just bear in mind that, you know, I'm an English qualified employment and privacy lawyer. I don't want to focus on English law. So what I'm going to try and do is highlight issues for you. And when I talk about something like unfair dismissal in the UK, you know, I'm referring as well to unlawful termination in other countries too, and things like that. And one last big caveat is we're not talking about the healthcare sector. Now, most jurisdictions have recognised that special measures are required to protect the most vulnerable in our jurisdictions. That would be a really easy conversation if we were discussing those sectors. We're talking about your typical office settings, or you know, your typical work settings that aren't within those more heavily regulated sectors. So can those employers mandate vaccination? Can they mandate testing? Can they even ask employees questions? Let's go back to that first question. Can they mandate vaccination? As I said, it's the big one. Outside of those regulated sectors, there isn't much legislation or even guidance that makes it mandatory or even suggests that that vaccination might be mandatory. On the flip side, it's broadly the case that there aren't any express prohibitions on requiring vaccination either. So there's nothing that says you cannot ask your employees to get vaccinated as a condition of employment. That's not a surprise because we are in uncharted territory here. And to be really clear, I'm not talking about data protection. I'm talking about kind of the more employment-based rules about whether you can ask your employees to provide proof of vaccination. We'll talk about data protection in a moment. In the absence of any clear rules, if you are considering this, you need to think ahead about what you're going to do if someone doesn't want to comply, because that's where your risks are. What are your next steps? So let's look at the most obvious and the most explosive. Would you be seeking to terminate their employment? Now, if you do that, in almost every European jurisdiction, you're going to face issues regarding the lawfulness of the termination, and you may also face claims of indirect discrimination. Data protection issues, yes, particularly if you're asking people to prove that they're vaccinated. And after all, don't forget that that information is going to be special category data. What's a lesser sanction? Maybe you're going to say, okay, we're not going to terminate their employment, but we're going to require that they continue working from home. That may suit many of your employees, but it's definitely not without its risks. In the UK, depending on the circumstances, an employee could use it as grounds for a constructive dismissal claim. Again, there could be mileage for an indirect discrimination claim. You might say, and I can probably hear some of you saying, oh, what do you mean? You've been working at home all of this time. What's the problem? But an employee, depending on the circumstances, an employee could very easily argue that they are being singled out or that they are missing out. The UK's Prime Minister Boris Johnson said as much, so the grounds are there. But as I say, I know a lot of you are going to go down this road anyway. So rather than tell you all of the risks, which I'm sure you're becoming familiar with, let's have a quick kind of whiz through what you might do to mitigate those risks. So we have a number of suggestions. First, really narrow in on why you are mandating vaccination. Focus your attention and your documentation, that's the important bit, on whether there are any alternatives and what you are seeking to do, or put it the other way around, what you're seeking to do and whether there are any alternatives. So are you mandating vaccination because you're trying to protect your workforce? Are you trying to simply discharge your health and safety obligations? If yes, most employer guidance outside the US stresses that the fact that while you may encourage vaccination, it's certainly not the only measure that you should be looking at. Things like masking, distancing, frequent testing, cleaning, staggered working patterns, allowing people to continue to work from home. They're all up there as other measures that could work probably just as effectively. If those measures are not going to be enough, explain why. For instance, is it because you know that your workforce is particularly vulnerable? Do you have a higher number of people who are particularly at risk? If yes, document it. Is ventilation more difficult? And leading on to another thing is, are you being asked to introduce this measure by your employees? And dialogue with your employees was my second kind of step or measure that I was going to suggest you take. Have you consulted them? In most countries in Europe, there is a requirement that you consult with your staff in relation to health and safety measures. You should be doing this already. But if you aren't, start doing it now. And when you do it, think about asking them how they feel about vaccine mandates. You may find that a large proportion of your workforce say that they're simply not comfortable coming into the office without assurances that people have been vaccinated, or that you're trying to get the vast proportion of your workforce vaccinated. If that's the case, then document it. And you can wrap this sort of process of dialogue in with the information gathering exercise, where you ask people to share information with you about their vaccination status, or you ask them whether they're willing to share that information with you. So that throws up all of the questions around data protection, and more on that in a moment. But if you find that a high proportion of your workforce is already vaccinated, you may feel that you don't need to roll out a mandate at all. And then you'd avoid all of the employee relations issues that could accompany a mandate. Now, just to illustrate this point, I was looking at kind of the most recent stats, and thanks to Reuters for this. But in Portugal at the moment, 87% of those eligible have received at least one dose of the vaccination. In Spain, that figure is about 80%. In France, they're at 76%. In the UK, they're at 74%. And just to give you an example outside of the European bloc, in the UAE, they're at a whopping 98% of those eligible having received at least one dose of a vaccination. To give you a comparison point, the number in the US is around 67% of the eligible population. Look, vaccination hesitance definitely exists outside of the US, but potentially not to quite the same extent. And that fact may actually help you frame, to go back to basics on what you are seeking to achieve and why. It could make a vaccine mandate in the strictest sense less necessary for your workforce outside of the US. However, I guess the converse is also true, in that with vaccination rates so high, you may feel that your risk of a claim is lower because there are fewer people to dispute it. So it's a game of numbers, essentially. A third measure for you, really think through any potential exceptions that you'll need to operate well in advance. If you do this, in the US, there's already exceptions on the basis of religion and medical status. Similar considerations will apply in Europe, but I'd actually encourage you to think more broadly, because your big risk is one of indirect discrimination. And for those of you who are not employment lawyers and not kind of working in that field, an indirect claim is where someone applies a blanket rule, and that blanket rule disproportionately impacts one group of people sharing a particular characteristic more than others. So you may need to think more broadly in relation to exceptions and some bending of any kind of firm and rigid rule in advance, so that you can that will allow you to mitigate your risk on that front and also just appear more reasonable. I'm conscious of time and I don't want to drone on myself for too long. And the key thing I haven't really spoken about yet is data protection, but we're going to move to the next question, which is whether we can mandate testing. And Meg, I think that's you.
Yep. So generally, mandating testing is not as contentious as mandating vaccination, but we've actually found that clients haven't been as interested in mandating testing as they have been with mandating vaccination. And in many cases, people are considering mandating vaccination as an alternative because it has become so burdensome. We suspect this is because frequent testing is expensive. Employers are likely going to be required to bear the cost of providing tests or to engage a provider to help with testing, but also because it's inconvenient for employees, meaning it's unlikely to be a measure which is backed by the workforce. In most European jurisdictions, generally employers cannot require frequent testing in your typical office setting. This includes France, Germany, Ireland, the Netherlands, and the UK. And lots of the issues that Gemma's just raised in relation to vaccination mandates will also apply to testing mandates. But particularly with testing mandates, you need to think through the practicalities. So firstly, how will you monitor it? There are a few options that we've come across. So firstly, will you ask employees who wish to work from the office only to return if they've received a negative test result in the last 48 hours, meaning you're essentially operating on a trust basis? Or will you ask employees to present a negative test result at the door for a visual check by reception or front of house staff? Or do you intend to keep a record of test results? Now, we'll go into more detail about the option of visual checks later on when we talk about the alternative of relying on COVID passes. But generally, a visual check is lower risk from a data protection perspective. The UK regulator has published guidance which says that if you are only conducting a visual check of someone's COVID status and do not retain any personal data from it, so you don't keep a record of it, this would not constitute processing under the UK GDPR, and so it would fall outside of the scope of the data protection law. On the other hand, keeping a record of test results is going to be much higher risk, and it throws up lots of data protection issues because you'll be processing health data. I think Gemma's going to go into these a bit more with the next question, but A person's COVID test results will constitute special category data under the GDPR, and it's going to be sensitive health data in many other jurisdictions. So you need to think carefully about how you're going to comply with your data protection obligations. You'll need to establish a legal basis and an additional condition for processing. And there are some legal bases you could rely on, but regulators across Europe have taken a different approach as to whether you can actually rely on them in this context or not. For example,
just to jump in there, because it is worth just covering off the legal basis. So as Meg said, it's special category data, so we need to look at Article 9. The most obvious one, consent, is really not available to you in Europe in the employment context. It is, interestingly, outside of Europe, because I've said we are looking at this more broadly than just Europe, but consent and express and sometimes even implied consent is actually completely fine in many jurisdictions across APAC. I'm thinking of jurisdictions like Singapore, Australia, New Zealand, Hong Kong. I'm losing the lists of countries in my mind at the moment. I don't have it in front of me, but across other places other than Europe and the UK, consent is a viable alternative. And don't forget that you will also have to you will also need to think about consent potentially for your transfer of the information too, if you're collecting any of the information. But in Europe, you really need to be looking at things like the employment obligation, so or legal obligation, the fact that you have a legal obligation that you have to comply with. And here I'm specifically thinking of health and safety. So you have to comply with health and safety measures. And if you need the information you're collecting for that purposes, that could be an option. The ICO recommended the public health ground as a potential option. Now there are some conditions to use of that ground. Firstly, that you have to have the involvement of a healthcare provider, or that you can provide adequate measures in relation to confidentiality. I also think that the substantial public interest ground is very helpful, but bear in mind that you're going to be having to conduct something akin to a legitimate interest assessment in that case. Sorry to have butted in, Meg.
I don't know at all. So taking the UK as an example, the UK regulator has said that if there is a good reason for checking people's COVID status, it's highly likely there would be an appropriate lawful basis for processing it, as Gemma's just said and given some examples. And this means you must be able to justify why. But other regulators in Europe have taken a different view. We suspect that the position may change if, for example, public health advice changes, or if it becomes a legal obligation for employers to ask for this information. So the second practicality I just wanted to consider quickly is, what will you do if someone refuses to comply? It's the same issue that we talked about with vaccination mandates. So let's say you wanted to ask employees to present their negative test result at the door. What will you do if someone refuses? Will you turn them away and ask them to work from home?
And don't forget, sorry to butt in again, don't forget that if you do this, so you're asking them, to present a negative check, and imagine you're trying to kind of reduce the amount of data that you're processing. So it's literally, I don't know how it could work, but maybe kind of literally either showing the results on the door or showing the actual kind of little test device if you have the equivalent of a lateral flow test in the UK or one of the rapid tests. Don't forget that as soon as you document that you've had to turn someone away, you're processing data again. So bear that in mind at your planning stage.
Yeah, it's a tricky one, that, isn't it? Because you're trying not to collect the data by doing the check, but may it end up inadvertently collecting it if someone refuses. So yes, it's much less likely that a discrimination claim could get off the ground with testing mandate. Because it's harder to anticipate a testing mandate adversely impacting one particular group of people over another. But if it does, you would have an opportunity to objectively justify the measure. And we think that it would be much more possible in this scenario. But also, as Gemma mentioned before, for employees who have the relevant length of service, there's still the risk of claims related to dismissal. Okay, I think next question.
Yeah, we've skirted around this, but can I ask staff to share their vaccination status with me? It's not straightforward. There are a whole load of countries, particularly in Europe again, where you run into various issues, mainly around data protection. And there are a few countries which take a particularly hard line on it, saying that you really should not be asking for health information at all. So no. I'm thinking of Belgium. I'm also thinking of Portugal, where we've had advice that says that actually you should be engaging with a health and safety agency who will be asking those questions on your behalf. And a similar principle applies in other countries where it might be okay to have that information provided to a doctor and then various assurances provided by a doctor to the employer. The setup is different to that which it is in the UK or that which it is in the US. So what are you going to do if someone doesn't share the information with you? Well, you're probably seeing a theme here. You always need to be thinking about what you're going to do in the event of non-compliance. And if you take any sort of disciplinary action, you're going to be looking at the same headline risks, unfair dismissal or other sorts of unlawful termination and potentially discrimination risks. Because even outside of Europe, we've had advice from countries saying, look, you can collect this information, but it's kind of hollow because you're not allowed to take any steps in relation to it. You're not allowed to treat someone differently just because of their vaccination status. However, maybe that's good enough. And when might it be good enough? If you're collecting this information in order to build up a picture about your risk profile. And in my view, it's a much more reasonable and measured request to make than mandating vaccination or mandating testing. Why? Well, again, back to these health and safety obligations, you have to minimize the risks faced by your workforce by introducing safety measures. And it's arguable that you can only introduce meaningful measures and make insightful decisions if you know who you're dealing with, you know who your workforce is. Because of that, I think you're probably going to be okay if you ask for this information. Probably. Like I said, it's not the same in all countries, and data protection legislation does still present a hurdle, but you can minimize those risks. You can do that by making sure your communications with your employees are clear about why you're asking the questions. You can do that in the comms, but you definitely will have to have a privacy notice of some sort, a short 2-pager that explains why you're collecting the information, what you're going to do about with it, what your legal basis for processing the information is. Now, by and large, although GDPR obviously doesn't apply across the world, by and large, GDPR is still a very high standard. So if you are complying with the notice requirements posed by GDPR across the world, that is going to give you a good position to be starting with. So in addition to notice, you want to make sure that the information provided, that any information that you collect, that it's secure and confidential, and as far as possible, anonymous. I'm using the word anonymous in the lighter sense, because obviously it will be difficult to ensure complete anonymity. But if you can show that actually what you're going to be relying on is kind of more like snapshot information of the stats in any particular location, so that you can use it to guide your decisions about getting back to the office or about other measures to put in place, and that's going to be a pretty good start for you. I'd also recommend that you consider making it a voluntary exercise, because let's face it, if people are providing information on a voluntary basis, they're less likely to complain. That's just the way it is. If people are told that they have to provide it, that's a different kettle of fish altogether. I appreciate that won't always be good enough. And one of my excellent colleagues, I think it was Anne in Germany, kind of made the really valid point that actually, if you are making it voluntary, it's somewhat circular, because the information that you get is inherently less reliable, because you can't use it as usefully as you can. So that will factor into whether it is a useful measure for you on a voluntary basis or not. Also, please make sure that you do a DPIA. You're asking for what will probably be a large amount of sensitive health data. Your DPIA will help you document all the things that we've been discussing about alternative measures, protective measures, kind of working through your rationale. It's going to help you on all of your fronts, really, not just data protection, but also in relation to your employment risks.
And I guess as well, the DPA will also go through things like access restrictions, how long you're going to retain the data for. All of these things, data minimization is still important, but that will come out of the DPA as well.
Absolutely. Okay, last question for today. Other alternatives. I have to say that the majority of our clients have tended to go for the strongest possible position first, and then kind of gradually move to perhaps a more moderate position. I understand why that's happening, but I would recommend that if you're at the stage of kind of planning your next move, it will be a good exercise to think about those potential alternatives first and to work out whether they could work for you. As I said already, that approach would help you mitigate your risks on all fronts, and always document your consideration of the alternatives. So one potential alternative is, can you operate on trust? Can you simply in your communications with your workforce say, look, please continue to work at home unless you've been vaccinated, and then don't require any proof, just operate on a basis of trust and social responsibility. If that isn't enough for you, be prepared to ask yourself and answer why isn't it enough for you, because honestly, if your driving force is mitigation of health and safety risk, and you're operating in a jurisdiction that doesn't allow you to collect this information or to mandate vaccination, then I would suggest that on that basis alone, kind of operating on trust and a direction for people not to attend the office unless they've been vaccinated is probably good enough. I would also suggest that you consider whether you extend that out and say, look, please only attend the office if you've been vaccinated, if you've been tested, or if you've recovered. That way, you've got less risk because there's less emphasis just on forcing vaccination, and it looks more measured and reasonable. That's the approach that's being taken with the EU COVID pass and the UK's NHS pass, and a number of other passes that are coming out all over the world. And yeah, that's another alternative. If you can't rely on trust alone, can you leverage the COVID pass? As a reminder, that pass shows those three things, right? Vaccination, testing status, and recovery status. If any of those apply, then you will have a big green tick. Now, many venues are being required to impose entrance obligations, so kind of large scale like conference venues. Nightclubs in the UK are recommended to require it, though I don't think it's obligatory. Some restaurants in various European states have to see the COVID pass before entry. I'm thinking of the Netherlands. There are certain venues in France, in Italy, which I think has the most extensive use of the pass. The pass is a condition of return to the office at country level, at state level, but it's a visual check. That's the thing to remember. It is a visual check of the COVID pass is required in order to work from the office. So if that is good enough, like I say, the visual check means that it's not processing. So you're outside the scope of the legislation. But remember that as soon as you keep records, you're back within the scope of GDPR. So I'd probably be counselling you to kind of put all your kind of protective measures in place. So even if you are going to rely on a visual check, have a notice just to kind of, that will be your catch-all just in case you end up making some incidental records to your DPIA, which would look incredibly positive because it will show that you've thought through the issues and that you've ended up on a visual check. Another measure could be simply to do nothing in relation to vaccination or testing and rely on other measures like masking, distancing, social responsibility, and the rest of it. Those are the main. I don't know, Meg and Will, can you think of any other potential alternatives that you've heard of? Or if not, I think we're done.
No, I can't think of any other alternatives. I don't know about you, Megan. But thanks very much to both of you for your great insights this morning. I'm afraid we didn't get round to answering viewers' questions. We'll pick those up offline. And of course, in the coming days or weeks, if you've got any questions, and please do feel free to reach out to Gemma or Megan. You've probably got their contact details, but they're on the website, and you can also probably find them on LinkedIn as well. So thanks very much for joining us this morning. We hope you found the session really helpful, and we look forward to seeing you on the next Fieldfisher Silicon Valley webinar. Bye.